Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today's topic, it's going to sound weird, is a will a trust? Before I get to that, if you would like to make an appointment, if you need to speak with me, if you want to go to my website and print out a download, I have a number of free handouts. Please go to frankbrunolaw.com. That's my name with law at the end. frankbrunolaw.com. Silly title, silly topic today. Is a will a trust? Well, in a certain sense, it is not silly. I was on the phone today with a prospective client, and this prospective client indicated that they had looked into this area, they had been on my website, they had Googled material, and they were looking at a method, at a way to give some property, some money, the assets that this person has to two adult children. And the person that I spoke to on the phone inquired about a trust. But in the conversation, it was clear, and the question specifically was asked, is the will a trust? Is the trust a will? Like the thought process of whether or not a trust and a will were separate documents was a little bit muddled, right? It's a layperson, so the prospective client didn't understand or didn't realize. So let me say clearly, a will is a document called a last will and testament, and a trust can be an irrevocable trust or a revocable trust. Oftentimes you'll see it written as a living trust. A living trust, I use that as a catch-all title for trusts, and a last will and testament are two separate and distinct documents. A trust is a will substitute. If you have a trust, you typically do not need a will. Now, when you do a trust with me and many other attorneys, if they're an elder law attorney, if they're familiar with this field, right? If it's a person that has studied and practiced and worked in this area, you will provide to the client both a trust for the distribution of the assets, for the protections that it affords, for the aspect of avoiding probate. You will engage with the person, give them a trust if that's what they want, and you will additionally prepare and provide to the client a last will. Why? Why do you need both? Well, if you have properly funded the trust, you do not need the will. However, should you prepare a trust and then subsequently inherit property, if it's not in the trust, it won't be governed by the trust. If you save up additional money and it never makes its way into the trust, then the trust won't address the money you've saved, the property you've inherited, anything like that. And therefore, we provide, as part of a comprehensive plan, a will that says, hey, if we missed anything, if we have after obtained assets, right? Assets obtained after the trust, put them in the trust at my death and put them there so they can be distributed pursuant to the rules of my trust. So a will is not a trust. They're two separate and distinct documents, but they can work in conjunction for an overall estate plan. I appreciate the question. I appreciate explaining this topic. And if you need me, if you would like to have a telephone conversation with me, could be Zoom, could be in person with masks and social distancing, but you can schedule it through frankbrunolaw.com.